Okay, hello there. I'm Stacy Strong. I'm an associate professor at the University of Sydney School of Law, and I am co-director for the Sydney Center for International Law. I see some more people are still joining, so we're just going to hold on for just a moment. It had slowed down for a moment on my end, and then it sped up again. So I want to make sure that everybody is on and connected when we get going here. Hopefully it's well where all of you are, whether it's in Sydney or elsewhere. Okay, so I would like to begin by acknowledging the Gadigal people of the Eora Nation, on whose land the University of Sydney stands, and the Gweagal people of the Darawal Nation, on whose land I am currently. I pay my respect to their elders, past, present, and emerging. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. Today's event is entitled How Private International Law Can Make the UN Sustainable Development Goals a Reality. The Sydney Center for International Law is proud to partner on this event with the Center for Asian and Pacific Law at the University of Sydney, as well as Monash University's Center for Commercial Law and Regulatory Studies and the Monash Sustainable Development Institute. Today's event grew out of a fantastic project managed by the Max Planck Institute for Comparative and International Private Law in Hamburg, entitled The Private Side of Transforming Our World, UN Sustainable Development Goals 2030 and the Role of Private International Law. The work is published in book form by Intersentia, and I believe that one of our speakers, Veronica Ruiz Abunig, has it right there, so she is showing it. It's a nice, thick book, so for those of you who like to read deep into the night, this will be perfect for you. The link to the book is on the webinar registration form, but I'm going to pop that into the chat so that everybody has it to hand. It's freely downloadable so that you can just access it whenever you like. We have a wonderful lineup of speakers today who I'm going to introduce only briefly so that we can get to the content of the presentations. Our first two speakers are co-editors of the book, and our other speakers are authors of chapters in the book. My introduction begins with Professor Veronica Ruiz Abu Nim, who is a senior lecturer in international private law at Edinburgh Law School. Veronica is qualified as a solicitor in Uruguay and has extensive practice in international litigation. Her research focuses on the intersection between private international law and various other disciplines, both within and beyond the law. Our second speaker, Mr. Hans van Loon, is a member and vice president of the Institut de Droit International, and my French is not so good as anything close to my Spanish. He practiced as a lawyer before the Supreme Court of the Netherlands and the European Court of Human Rights, and was a deputy judge in the Hague District Court. You may know him from his 17-year tenure as the Secretary General of the Hague Conference on Private International Law. Professor Vivian Bath is Professor of Chinese and International Business Law in the University of Sydney and Associate Director for the Center for Asian and Pacific Law at the University of Sydney. Vivian is also a Senior Research Fellow of the Asia IP and Technology Law Project at the University of California, Berkeley School of Law. Vivian has extensive professional experience in Sydney, New York, and Hong Kong, specializing in international commercial law with a particular emphasis on China and the Asian region. Dr. Drosos, sorry, I'm trilling the R now. Dr. Drosos Stamboulakis is a lecturer at Monash University and is admitted to practice as an Australian lawyer. Drosos is the deputy convener of Monash's Commercial Disputes Group and coaches the Monash Viz International Commercial Arbitration Moot Team. His research spans commercial arbitration, comparative law, and private international law, and intersects with biodiversity and sustainability. Finally, I should mention Professor Jay Sanderson, who is unable to be with us here today, but who is Drosos's co-author on the book project. Jay is currently professor and head of school at the School of Law and Society at the University of the Sunshine Coast. The format of this presentation is pretty straightforward. Our speakers are going to each speak for about 10 to 15 minutes, taking us up to about the 50-minute mark, and that will leave us about 40 minutes for questions and answers. If you put your questions in the chat feature, you're all familiar with how to do that, I think, at this point, I can moderate them and present them to the speakers at the end. Before beginning, I would like to acknowledge the kind assistance of Carla Viola and Andy Netherington in putting this event together. I should also note that this event is being recorded and we will have it posted on the Sydney website in due course. And now I will hand the mic over to our first speaker. Professor, I wasn't quite sure how formal to be here in Australia. We just say, Veronica, the floor is yours.
Thank you very much. Thank you very much, Stacy, for your very kind introduction. And yes, I adopt the informal setting. I very much prefer that. So first of all, I would like to thank the organizers from the University of Sydney and Monash University for putting together this seminar. We are delighted to be able to share with you some of the insights of this project on the private side of transforming our world. I will be sharing the screen with you. So let me do that and hope it all works as it should. So there, fantastic. There we go. So in the next 20 minutes or so, Hans and I will share with you some of the general insights of the project, where we had the opportunity to work with a fantastic group of scholars, including the distinguished speakers we have today with us in the panel. So this is the general overview. I will talk on the first 5 points, and then Hans will take over from the 6th to the 10th point. And before we get started, I wanted to emphasize that we see this project as a beginning and as an agenda creating project that provides rich and insightful insights for future agendas on private international law and sustainable development, both in general in relation to private international law as a discipline, but also in relation to specific objectives of the United Nations agenda. And I think this is what actually we very much emphasize in terms of the agenda creating effect of the project. It allows a dialogue between policymakers and academia. It provides opportunities for further engagement of private international law with issues on sustainability and development. There is a need to reinvigorate that individual enabling dynamics that are both core to private international law and to sustainable development. And on that note, we can start the presentation itself. So, as we know, the world is in a deep crisis, and the COVID-19 pandemic has only exacerbated that. So we have, on the one hand, the social problems that we all know well, poverty and inequality, but this is accompanied by a threefold planetary crisis of climate change, nature loss, and pollution. And this is a conundrum for the world that we live in. So the need for economic development in relation as a response to poverty has been long in the United Nations agenda, and we know that, for instance, the 2000 from the UN Millennium Goals that was the basis on which work was developed from 2000 to 2015, very much engaged with that, particularly in relation to developing countries, and made considerable progress in relation to that. But we know that the awareness of the climate crisis and the environmental crisis, it's much more in its infancy in terms of how to tackle it, how to engage with it. And I can only refer you to, you know, the COP26 in Scotland in the past few weeks. So the dilemma is how to couple development with sustainability. And in that sense, that transformative nature of the agenda is very much linked to that conundrum. On the one hand, development to reduce poverty must continue, but that development needs to be sustainable development, because the use of carbon fuels and land resources in which development has been in the past been fueled by has devastating effects on the planet. So this is very much the setting we are in, is something that we are all very aware of, and it's what the agenda itself tries to tackle. So the agenda, the United Nations General Assembly adopted the Agenda 2030 on Sustainable Development on the 25th of September 2015. And the core of the resolution are these 17 goals which are in itself provided on a range of topics that cover more or less all the global challenges that are necessary to tackle, and these are provided with targets, specific targets in relation to each of the SDGs, and many more indicators to measure the advancement towards those targets. So the agenda itself is all inclusive in several ways. So on the one hand, one main difference in relation to previous work of that kind, and particularly the Millennium Goals, is that dual nature, the coupling sustainability with development, and generating that need for transformation. And in relation to that, coupling sustainability with development means also that the agenda is directed not only to developing countries as the work in the previous Millennium Goals, but very much also to countries in what we say the global north. The development and the practices and the way development has happened in the global north needs to be transformed into sustainable practices, and the global north has generated much of the impact that we're trying to revert somehow in the agenda. So these are the 17 SDGs, going from no poverty, zero hunger, all the way down to responsible consumption and production, climate action, and you have the 17 in front of you. One thing to notice in relation to the agenda itself is that the first 15 are substantive objectives, and 16 and 17 are very much what we call transversal, in a way instrumental goals to achieve the agenda as a whole. So 16 is very much connected to the rule of law, and when we think about law and sustainable development, the first thing that comes to mind, and where much more research has been done, is in relation to SDG 16, and very much the rule of law and the role of institutions. Of course, the project also looked at that, and this is the project looked at each and every one of these goals, but the work itself in relation to private international law has been taken in relation to all of this, and in particularly SDG 16 is something that we engage also with the institutional aspect of it in relation to private international law. What we have on the screen here is an example, so we understand a little bit better what is the governance tools that the agenda uses. So this agenda uses very much the target, and you have the kind of targets here just as an example in relation to climate action. So target 13.1, for instance, talks about resilience and adaptive capacity to climate hazards and natural disasters, and then it provides indicators to measure that. So this is a specific way of measuring and including goals and incentives and generating that that mechanism. The mechanism itself of goal setting of the agenda is not without critics. Is very quantitative in nature, and we are all very aware that to generate that transformation that is necessary, it's important to generate transformation that is qualitative in terms of human behavior. So in that sense, we need to see these indicators as a way of advancing in a particular way, but very much very important also to generate data gathering that is effective to further policy making. So even though there is not free from criticism, it allows moving forward in relation to advancing the goals. So as I said before, the SDGs are all inclusive, and they're all inclusive in relation to that dual nature of coupling sustainability with development, but they are all inclusive also in relation to the actors that are the addressees of the United Nations agenda. So this core idea of leaving no one behind is in relation to working with countries, and in that sense developing and developed countries, but more centrally to the agenda is the idea that states are important actors, but the private sector, civil society, all of us, we are all important actors, and we are all empowered to act in the promotion of the goals. So that inclusivity of the agenda is essential to understand the agenda itself, but it's also essential to understand the role of private international law in relation to the agenda. So that on that we can relate that inclusivity of the actors that are somehow the ones who need to advance in progress in the agenda in various ways. So the SDGs are not legally binding. They articulate aspirations, and we have to take that in, and they are very ambitious in those aspirations, and we all have the responsibility to work towards those goals. So this type of target setting, as I said before, is about transformative in terms of regulating human behavior, and in that transformation, the private sector has a very important role to play. So it's not only through public, but through private action that we can all engage in advancing the goals. And in that sense is that private international law, in its role as coordinating and generating bridges between different private laws in our world today, has a very important constructive role to play. So concretely to the private international law interplay with the SDGs. The agenda itself seems to have a blind spot for private international law as a discipline and for private international law instruments. So if we look at the agenda, the tone in terms of the recognition of international law is directed to public international law. It's very much the awareness, and there are several reasons that can explain that in terms of the discourse of the agenda. But if we look at the agenda itself, there are implicitly several targets that engage with private international law, with private action, and you have just a couple of them on the slides. So what the project set out to do was, on the one hand, bring to the surface the forgotten by the SDGs role of private international law in regulated cross-border conduct affecting the life of us all and the planet as such, but also exploring in relation to each of the SDGs how private international law could or should be reformed to better engage with sustainability and development, and having that important SDG institutional component in mind at all times during that work. I don't know how I'm doing for time, but I don't want to exceed my time. I'll leave it to Hans to continue. Hans?
Yes, okay, thank you. Good evening, everybody. Let me first join Veronica in expressing my enthusiasm and thanks to Drossos and Vivienne for taking the wonderful initiative for this webinar. Drossos and Vivienne organized this virtual meeting, as they said, to keep the momentum going from the conference that took place in September at the Max Planck Institute in Hamburg. The Hamburg conference really was an extraordinary event, inspiring event, and I think this conference is proof of that inspiration. Now, the idea for the Hamburg conference and for the book came up when Veronica and Ralph Michaels and I met in the spring of 2018 in the gardens of the Peace Palace, which is the seat of the World Court, of course. And from my window, I have a view on those gardens. Ralph, Veronica, and I were struck by the fact that the United Nations agenda for the current decade, Agenda 2030, does not refer at all to private or private international law. And we felt that these disciplines do have a role to play in a globalizing world, which after all is made up of a patchwork of legal systems, of commercial law, of private law. And so we agreed that we needed a conference and that we needed a book. Now the book is about to be published. In fact, Veronica already has a copy. She's a lucky one. I don't have one. There it is, nicely presented. As you know, it's also freely accessible online, has 70 chapters on the 17 sustainable development goals, plus an introduction that Ralph, Veronica, and I wrote together. But as Veronica has emphasized rightly, we don't see this book as the end of a process, but as the beginning of a process of engagement, deepening engagement of private international lawyers, but perhaps also of the whole private sector. Okay, now it's one thing to share an intuition that the SDGs and private international law should speak to each other. It's something else to explore that in depth and detail for each of these 17 SDGs. In fact, our own understanding of that interaction increased, I think, as we read the papers and wrote the introduction. I don't know about Vivienne, Drossos, and Jay, but this was also true, for example, for one of our authors, Klaus Beiter from Namibia, who wrote on SDG 4 on education. He started with the idea that education is typically a responsibility of the state, public responsibility, a public matter. However, thinking further about it, Klaus realized that nowadays many forms of education are organized privately, and that this may involve cross-border aspects with private international issues attached to it. He noted, for example, that when you have a contract between, on the one hand, a student or a teacher in a developing country, and on the other, a foreign private educational institution, and the contract refers all disputes to the courts of the home state of the education institution, let's say Australia, that is very problematic for a student or teacher in a South African country, because they cannot normally be expected to bring a claim in the courts of Australia, and would, of course, by far prefer to be admitted to the courts of their own country in Africa. And the same applies to the applicable law. So I will now be giving a few other concrete illustrations of the interaction between the SDGs and private international law. Next slide, please. Thank you. My first case study is on poverty, already mentioned by Veronica. SDG 1 deals with ending poverty everywhere. Now, that objective, as we know, of course, is unfortunately still a huge challenge for many developing countries, especially in Africa and parts of Asia. But poverty alone, as a ground for taking children away from their parents to be adopted by others, in particular overseas, is not in accordance with the United Nations Convention on the Rights of the Child. And when poverty is the main reason why parental responsibility would be terminated, then SDG 1 on poverty requires that instead families should be offered support in to keep their children. And that is also what the Hague Intercountry Adoption Convention aims at, private international law instrument. According to the convention, which is in force in 104 countries, has been in force for Australia since 1998, states should, as a matter of priority, take measures to enable children to remain in their family, in the care of their family of origin, and if that is not possible, in a circle, in a wider circle, but still as closely as possible to the original family. In any event, the convention only permits an adoption abroad if the placement of the child within the country has been given due consideration, and that is the so-called principle of subsidiarity. So poverty alone is not a sufficient ground to declare a child adoptable and have the child adopted, let alone adopted across borders. And the convention, as you may know, has established cooperative machinery, safeguards, procedures, system of central authorities, and established joint responsibility of the state of origin of the child and the state of destination of the child. Next, please, Veronica. My second case study deals with decent work, SDG 8. Many cross-border workers carry out work temporarily in host countries, but we know too well that those workers are particularly vulnerable to lack of protection and abuse. They are prone to discriminatory practices and harsh working conditions. Social dumping is too often unstoppable. And I think a very deeply shameful example is offered by the construction works for the World Cup 22 in Qatar. It is estimated that more than 6,500 migrant workers from India, Pakistan, Bangladesh, Nepal and Sri Lanka have died in Qatar since it won the right to host the World Cup in 2010. That is, of course, completely unacceptable. Cross-border workers around the world should have access to courts and should be protected by laws. And private international law obviously has a critical role there. Now, for example, in the European Union, the Brussels I regulation lays down special rules on jurisdiction and enforcement of judgments related to employment contracts. I've detailed them on the slide. I will not go into them in any detail, but the aim is to enable the worker to be able to have access to the courts that are closest to where he works or where he or she resides. Next, please. The same goes for the applicable law, where we have in Europe the Rome I regulation, special choice of law rules to protect the employee. And then on top of that, there is a directive which leaves a little more freedom to the implementing states, the Posted Workers Directive, which complements the Rome I regulation and provides additional specific rules on posted workers who are temporarily
Are other people able to hear Hans?
No, I'm not. And actually, he's frozen on the screen as well. So
Let's just give another moment just in case it clears up. We may need to jump to Vivian's presentation a bit early, but we'll just give it a moment. Veronica, can you tell me how many more slides Hans has?
yeah, not that many. I'm happy to go on if you want, but entirely up to you.
Why don't you go ahead and see if you can finish up his slides for him, if you're familiar with what he's going to say.
Yes, I can resume where he was talking about in relation to the Posted Workers Directive and see this is something that Hans has worked a lot on, and actually this is something that we see developments, including after the Hamburg conference, in terms of interest in doing more at the global level. So what Hans has just described is what the kind of the framework in the EU, but globally there's nothing in relation to kind of migrant workers. There's no global framework of that kind, and it would be interesting to see further work, including coordination and cooperation, for instance, between the International Labour Organization and the Hague Conference that could somehow provide that kind of a global framework for migrant workers. So this
Indeed.
is something.
Okay. I think Hans is back.
Oh. Oh, sorry. Sorry, Hans. Okay.
Oh, thank you so much for taking. No. I think it was absolutely right. I don't know what happened, but there we are. So indeed, there in chapter 8 of the book written by Ulla Liukunen suggests that perhaps the Hague Conference might do work to create a uniform system, not just for Europe, but for the whole world. And I think it's badly, badly needed. My third example deals with combating climate change, that is SDG 13. And let's just look at this this picture. This is a case before the courts in Germany. We have a Peruvian farmer, Mr. Llulla, who has sued with the help of German NGOs, the German energy giant RWE for damages. Why? Because Llulla lives in the Andes Mountains in Peru, in South America, and the glacier near his village, which you see on the picture, is melting. Why is it melting? Because of climate change, he argues. And the result is that the lake, which you see there behind his village, is overflowing. And Mr. Llulla has had to build pipelines to drain the excess water to keep his village, his home, from being overflooded. And he claims that RWE, the defendant, is partially accountable for this because RWE is responsible for about 0.5% of the global emission of CO2, greenhouse gas, which causes warming up of the planet. Now, this is a classical private international law case. The first question, of course, which they had to face was, shall we sue RWE in Peru or in Germany? Obviously, they chose Germany. And under the Brussels I regulation, the German courts have jurisdiction and cannot apply, for instance, the forum non-convenience doctrine to say, no, you'd better go to another court. Llulla lost in the first instance. The first instance court said, oh, well, come on, this is not serious, out of my court. However, the appeal court said, yeah, there may be something to this. And we appoint experts to determine the causal relationship between the RWE's greenhouse gas emissions and the damage that Mr. Llulla claimed. And that's still going on. It has been delayed because of the COVID problems. Second question, what law applies? Now, to the defendant's liability, if there is any. And here, both German law and the European Rome II regulation provide that the plaintiff has a choice, and again, for obvious reasons, German law is supposed to be applicable in this case. So here again, we see the relevance of private international law. Now, I think I'd better skip the last example, ACPAM versus Shell, because that is maybe something that Drossos will be talking about, and I just will conclude with my conclusion, which is that, first of all, as Veronica has rightly emphasized, the SDGs represent an original quantitative approach, target-setting governance strategy with benchmarks to measure quantitatively progress, and of course they are not legally binding. They articulate aspirations, but implementation of the SDGs also requires qualitative changes in human behavior, not least of all of us as consumers. So norm production and rulemaking remain crucially needed, complementary and implementing strategies to achieve the Sustainable Development Goals. And the fact is that most transactions, most investments, most destruction of our environment happen not through public law, but through public action, but through private action. And they are governed not exclusively by public law, but also perhaps predominantly by private law and private international law. Moreover, the world is a patchwork of legal orders and legal systems in constant flux that govern our human activity. And the role of private international law is to make it possible to connect between these systems, to mediate between these systems and orders by providing rules on jurisdiction, on applicable law, on recognition and enforcement of decisions, and also on cooperation between administrations and courts of different countries. Now, these rules intersect with public law, human rights, migration, competition, data protection. So the idea that private international law is an isolated discipline is no longer tenable. It's in fact seriously wrong. And I would suggest private international law is sort of in the middle of developments in this world. And that means also that private international lawyers must be very aware of all these intersecting other systems of public and private law. In brief, it's critically important to work on the private side of transforming our world, and we hope that this seminar and our book will give the push that is necessary in that respect. So thank you very much for your attention, and thank you, Veronica, for helping me with these slides.
Thank you, both of you, for your excellent presentation and kind of introduction to the scope of this, of both the problems and what the book and project is attempting to address. We're going to send it now to Vivian, who will take us on a more specialized path.
Thanks very much, Stacey and Veronica and Hans. Drossos and I generally get to be at the end of the day if everybody else gets to talk about their SDGs, so this is very good for us to be able to put forward our own chapters at this early stage, relatively early stage in the evening. I'll just share my screen here. Okay, can everyone see that? Yes. So my SDG is SDG 9, which is industry, innovation and infrastructure. Now, that obviously covers an extremely wide field, and it's a very ambitious SDG. So it focuses on developing and less developed countries, and it includes within it infrastructure, inclusive and sustainable industrialization, assistance to smaller enterprises and improvements in scientific research, technical capacity, research and innovation. Now, I obviously couldn't cover all of that in the space of one chapter, so I decided that I would concentrate in particular on the concept of sustainable infrastructure. And I think with this, it's very important to dwell on the word sustainable in terms of what we're talking about when we are actually talking about the construction and operation and long-term commitment to infrastructure. Because what it has to be is it has to be high quality, reliable and resilient infrastructure that is fit for purpose in the future. And it has to not just support economic development if it's to be truly sustainable, it also has to support things like human well-being, accessibility and connectability. And infrastructure projects are often large, always expensive. They take a long time to build, and they have a very wide-reaching impact. And it has to be remembered that the long-term impact is essentially on the host state, of course, the investors, financiers and contractors, but also on the domestic stakeholders, the people who lived on the land, who continue to use the infrastructure, whose lifestyles are improved, hopefully, or not improved, as in many cases, by the actual construction and operation of the infrastructure. So you really have to, in terms of the SDG 9, look at the sustainability of the entire infrastructure project and its contribution to sustainability and the development of the host state. So it's necessary to look at the short and long-term impact of the local stakeholders, and also to look closely at the basic contracts and legal frameworks which are required to make infrastructure possible. And similarly, to look at the assessment of the potential impact of disputes on the project and the host state, which plays multiple roles, excuse me, as regulator, contract party, guarantor, lender, borrower, and protector of domestic stakeholders. Excuse me just a sec. Now, private international law, as Hans pointed out, has a very important role in terms of the SDGs, and it has a very important role in relation to infrastructure. In fact, all three of the traditional parts of private international law, that is choice of law, resolution of disputes, and enforcement of judgments or arbitral awards, come up at all stages of an infrastructure project. So they're relevant to setting up the project in the first place, they're relevant to the construction stage, the operational stage, and also the stage, if you get to that, of winding it up. It's relevant to financing, it's relevant to construction, it's relevant to the import of intellectual property, it's relevant to employment, and it's relevant to the treatment of the domestic stakeholders whose land, for example, might be appropriated. So it plays a role in all of these particular aspects. Now, private international law in terms of actually doing a project has been particularly useful to people putting it together because it has come to play a very substantial role in terms of risk mitigation, particularly in terms of project finance. And this is particularly because of the utilisation of the doctrine of party autonomy to choose the law which applies to the sort of major finance, construction and other contracts which are required, and also to choose both the method and the location of dispute resolution. So it's been adopted not just by the parties, that is the financiers and the other people involved, it's also been supported. You'll see it in various documents sort of put out by international organisations talking favourably about risk mitigation and bankability of projects. And of course, it's been an absolute boon to the major law firms which work in this particular area. And the question, I think, also has to be asked here when we look at it as a factor of risk mitigation, how necessary it is in various contexts to actually engage in risk mitigation. You know, the major banks will decide to use the law or want to use the law and the legal system with which they're familiar. The lawyers probably want to use the law and the legal system with which they're familiar. But of course, the legal system which misses out in this particular context is the host state. And as Robert Wye and various other commentators have shown so ably, the effect of this internationalization of contracts and dispute resolution is often the delinking of the contracts from the state and the stakeholders who are actually most immediately concerned with these types of projects, and that is the host state. Because by nominating always foreign law and foreign dispute resolution, you're effectively separating the host state and its legal system, and in particular, its interests in sustainability and the sustainability of the project, not to mention the interests of the domestic stakeholders in the project, from the process of resolution of disputes and the process of actually enforcing the ultimate conclusion. In particular, the risk is that provisions in host state law, which are designed to provide for sustainability and the protection of domestic stakeholders, will often be irrelevant or disregarded in the chosen forum, which is doing the resolution under the contract and the terms of the contracts which are actually provided. Associated with this is the fact that when you have a really complex project, and most of these projects are indeed immensely complex, the application of these private international law rules relating to choice of law and forum, as well as rules on jurisdiction and enforcement, may actually affect the overall sustainability of the project by allowing for, and in fact even promoting in some cases, the fragmentation of disputes and different decisions on liability. When you combine this with the different positions of subcontractors, foreign employees, local businesses, and the potential for the use of foreign law as enhancers example, for example, of employees going across border, you can see that there's considerable prospects for difficulties going forward. Now, an example of this is a case study of a very large and economically important resort complex in the Bahamas. I appreciate that resorts are not generally regarded as infrastructure, but in this particular case, this was extremely important for the economy of the Bahamas. It was a very large and significant project. If you look at the way in which it was put together, though, loan finance was provided by the China Export-Import Bank pursuant to a facility agreement which was governed by English law, with disputes ideally to be submitted to the English courts. The developer was actually in New York, and so the principal construction contract, which was with the grandchild of a major Chinese company, and the shareholders agreement between the various developers was governed by New York law and New York courts. And there were other agreements related to the loan facility governed by the laws of England, British Columbia, Texas, and New York. The only agreements, in fact, which was subject to the law of the Bahamas were the grant of security to China Export-Import Bank over assets in the Bahamas, and ultimately the winding up proceedings. So even there was a conflict between the Delaware court and the Bahamas, both of which started hearing the winding up proceedings. Now, ultimately, the dispute was settled, but not by the intervention of any of these courts or by any agreement made by the parties in the contracts. It was settled because the Attorney General of the Bahamas led a delegation to Beijing, and an agreement was struck in Beijing. The original developer is still suing in New York, apparently. So this is actually, I think, quite a good example of the sort of fragmentation which you get with this particular dispute, and the fact that in all of this, the host state, although it had given substantial concessions, although it was vitally interested in the project, although it was, of course, very much concerned with the interests of the employees and the other people in the Bahamas, were not actually party to the documents, and therefore didn't really play a role at any stage until the courts of the Bahamas started to get involved in the winding up project. And this really has an impact in terms of how you look at the question of sustainability with this type of package. Now, there are two other aspects that I wanted to point out, again, rather briefly, and these relate to, I suppose, other forms of host state liability. Now, there are various ways in which the host state, of course, is always involved in a project of this kind. It may be involved as the guarantor, it may be involved as an investor, it's always involved as a regulator, it may be asked to give concessions, it may be asked to give guarantees, and of course, it's its responsibility to deal with local law issues and to try and protect the issues of the local stakeholders. But in particular, it may also find itself involved in guaranteeing the viability of an infrastructure project because it has either an investment agreement signed with the investors in a particular project, or it might have an international investment agreement signed with the host state of the investors in a particular project. This, of course, is a fairly controversial issue at the moment. But this is on top of, in many cases, the contract documents which set up in the project in the first place. Now, why is private international law relevant here? It's relevant here because essentially you're introducing more systems of law into the way in which the project is set up and the way in which it's actually regulated or disputed. So in the case of investor-state disputes, private international law may actually facilitate, and there's a lot of argument that it does facilitate, the use of international or foreign state law in place of host state regulation, even when the host state regulation incorporates sustainable development principles. That is, just as with the contract documents, you may find yourself moving offshore and being subject to a law which is not host state law and which therefore is not looking necessarily at the question of sustainability. And this is despite the fact that at an international level, sustainability and the role of the SDGs is acknowledged in numerous, admittedly soft law or non-legally binding instruments. And the final thing which I looked at in my chapter, but I probably don't have much time to talk about here, is the question of host state liability and the question of sovereign immunity, because often as part of the package of documents which are put together for these infrastructure projects, there will be a very comprehensive waiver of sovereign immunity by the state. In fact, this is generally routinely asked for by international lawyers, and it's also referred to in the documents of various of the international agencies as something which the state should give. The thing is, of course, in terms of sustainability, both at the more macro level, that is the viability of the state itself, when you're looking at particularly at the less developed countries, or when you're looking at sustainability in terms of does the state have enough money to actually finish the project or look after the interests of its stakeholders, sovereign immunity is not necessarily very conducive to that end. So I include it as the final point of private international law, since under enforcement rules, they're generally done by the law of the jurisdiction in which enforcement is sought, rather than as a public international law issue. Now, the question is then, what can be done in relation to this? Because an important part of the project was suggestions for reform. And although it's very difficult to deal with some of these private international law, particularly the principles in relation to autonomy of choice of law and autonomy of dispute resolution, particularly given the status that international arbitration has acquired over the years, it is important, I think, that we consider that if we're going to recognise the importance of sustainability as a concept in domestic law and in international investment agreements where it might be referred to, or in international trade agreements where it's often referred to, in documents such as the EU's recent proposal for amendments to the Energy Charter Treaty, or the UN Guiding Principles on Business and Human Rights, all of which recognise the concept of sustainability, that there needs to be some way of bringing that concept of sustainability into the way in which we deal with infrastructure and the way in which we look at the governing law dispute resolution questions. So generally speaking, I would say that the question of sustainability and the law of the host state that needs to receive greater consideration, even when foreign law is used in relation to disputes between the parties, and it needs to come up in terms of dispute resolution. It needs to be considered by the forum state. And similarly, the interests of the host state in, say, protecting small businesses and its employees, as Hans was mentioning, in infrastructure should also be given greater recognition in foreign courts. The fact that the host state has an interest in these particular considerations in order to ensure the sustainability of the project. And so there are various ways in which could be looked at in terms of dealing with this. One, for example, is that where you have a foreign court and a foreign forum, that the foreign court, instead of just dismissing questions of sustainability under host law as something which has nothing to do with their considerations, if, say, they're using English law in relation to a contract, should actually look more closely at the question of public policy and should consider that the important issues of the host state and sustainability are in fact a relevant matter for the forum state to look at. Generally in private international law, they won't consider that. They'll only look at public policy in the context of forum state public policy. But one way in which the international concern with sustainability could be given perhaps a bit more life is to broaden consideration of sustainability as a public policy concern. The second issue is in relation to fragmentation and the question of how you ensure the sustainability of a project by essentially keeping it together. And for this, I think that it might be necessary to look again at the question of choice of the parties in terms of the forum and the choice of the parties in terms of the choice of law. That essentially this delinking of international projects from the place where they actually take place as an automatic thing. That is, oh no, we're not going to use the law of wherever it is because we don't like that law, is something which is not just for the parties to look at, but also perhaps international principles of private international law. And finally, because I know I'm already over my time, I think generally that there does need to be, in private international terms, a larger role for sustainability considerations in investment disputes, not just because it's required by the treaty, but because as a matter of the law to be applied, sustainability is one of the principles which should be given some consideration. And in terms of sovereign immunity and state liability, that we also need to find some way in considering sustainability, both in negotiating waivers of sovereign immunity. That is, that we have to look at the ability of the state to actually pay before we have it back up or support or guarantee contracts for which it cannot possibly end up liable for the debt because it just can't pay them. And it also, I think, should be taken into account in enforcement in terms of, say, enforcing an award in Australia or a judgment in Australia. The question of to what extent there are, in fact, funds available to meet a foreign judgment when those funds, when used to pay off an investor, are in fact taken away from important considerations of sustainability and basic issues that are necessary for the population. Now I'll stop here because I'm already talked over my time and hand over to Drossos.
Thank you, Vivian. Drossos, over to you.
Thanks, Vivian, and thank you, Vivian, had the genesis of putting this webinar together, and to Hans, Veronica and Ralph, who can't join us as the editors of the book, and for really just the foresight in putting together such a wonderful project and allowing me to participate in it. I'm going to talk a little bit about SDG 15, and I should also thank my co-author, Jay Sanderson, who can't make it today. And SDG 15 probably has the most direct links to traditional conceptions of sustainability, because SDG 15 is referred to as, colloquially, the title is Life on Land. In other words, all terrestrial environmental concerns, excluding climate change and oceans, which are dealt with in other SDGs that surround SDG 15. So that includes things like conserving, protecting, sustainably managing all kinds of ecosystems, including forests, biodiversity, native flora and fauna, wetlands, combating desertification, and so on. And the primary emphasis of my presentation today will be on looking at how private international law can assist with achieving some progress in these terrestrial environmental concerns. Now, this has to be addressed, I think, at the forefront, because the hope for private international law arises here because of the ineffectiveness of state agreement and the ineffectiveness of public litigation to achieve these ends. I mean, you can look at any document from the UN Economic and Security Council, various reports and various measures. I focus predominantly on biodiversity, but in any of those metrics. And the consistent theme is that markers are going backwards, often at an increasing rate. So rather than addressing sustainability, rather than addressing biodiversity loss and so on, we're actually going in the wrong direction. And I probably can't put it any better than David Attenborough's recent film, A Life on Our Planet. In those stark figures, I'm sure a lot of you have seen it, 68% decline in biodiversity in the populations of mammals, birds, fish, reptiles across the board, 68% since 1970. Now, if you extrapolate those rates even slightly beyond, you go to 2030 or any of those time periods, 2050 and so on, it is an alarming picture. It already is alarming and it's getting worse. So that's where the hope for private international law comes from, because the major contributors to this environmental harm are, because of the locus of power, not just due to their status, transnational corporations. So that's sort of the genesis of this project and understanding SDG 15. And I should say that legal efforts in this respect have continued for decades now. As early as the early 90s, there was a proposed Hague Convention on Civil Liability for Damage to the Environment, which was quite an ambitious convention, which sought to set out all kinds of responsibilities for transnational corporations and various remedies directly available to pursue corporations where they did cause environmental harm. Now, that didn't succeed, but I want to cycle back to that at the end of my brief presentation and suggest perhaps that we're returning to the same sort of drivers and approach, which in a stronger fashion. So I'll pause that for now, but come back to it. On its face, SDG 15, and broadly speaking, I'll replace SDG 15 with sustainable development because that's really the goal of what it's trying to achieve. Doesn't really square well with private international law. The main reason being that this aspirational goal of sort of conserving, protecting, and so on meets what's commonly referred to as a neutral procedural territory. Right? The rules of private international law, and I'm conscious quite a few in the audience are not private international lawyers, are essentially rules for allocating which legal system has a go at various stages through recognition and enforcement, jurisdiction, the applicable law, and so on. Traditionally, private international law's role has been to say, we don't look at what's going on, we don't look at the transaction itself, we don't consider whether it has environmental impacts, we simply apply these apparently neutral and apolitical rules, which lead, as Vivian mentioned, to various laws according to either what law was chosen or what law applies in default. So there's a bit of a structural mismatch there between the public good nature of protecting the environment and the private rights of parties and litigants to pursue their own remedies. And they don't line up very well. It's often very difficult to find an individual identification of interest that would actually support individual claims over environmental harms because they're so diffuse. And there's been quite some high-profile litigation, which I'll talk about shortly, which tries to do that. I'll also note just two things and then really commence at looking at the private international law aspect. Firstly, environmental protection is really not prone to being privately enforced, predominantly because we don't know often who has the rights to enforce. So we lead to sort of conclusions like the rights of the river and so on, and representatives of bodies that are not traditional bodies, because it's unclear which parties have a right to enforce and whether or not they can start private proceedings themselves or whether they can be commenced in their stead. So, for example, an NGO or some other body acting on behalf of affected populations. And common situations of environmental harm include, for example, oil spills that have occurred. There's been a series of cases in relation to Royal Dutch Shell, I think now Shell will moving to the UK shortly. And finally, what kind of remedy can you get? And if it's a monetary remedy, who gets it? And how do we split it when it affects potentially tens, hundreds of thousands of people, even if you can prove that the environmental harm existed? So it doesn't square well with the private nature of rights doesn't square well with the public goals in SDG 15. Now, this is not necessarily the end of the story, but I think what it highlights is that ultimately much of this question, much of what we're looking at in relation to sustainable development and private international law is broadly conceived as a political question. There really are bounds to what law can achieve on its own. That doesn't mean we put our hands up and stop, but it's, I think, just to position the contributions of private international law here, in particular because of the corporate form, meaning that we have a limited form of corporate responsibility, which due to outsourcing and the use of daughter companies with a controlling parent, limits responsibility. So the goals of SDG 15, these protection and other goals and so on, as Veronica said, seem to have a blind spot for the role of private international law. And I don't know that that was intentional, but it reflects, I think, the view that private international law is predominantly a facilitative mechanism, as Vivian suggested. It enables parties to conclude and enter into contracts, enforce resulting judgments, choose the law that they like, and states broadly stay out of that conception. And that's what can be referred to as sort of the win-win scenario in a very glib format, i.e. that the profit motive can be harnessed to achieve public goals. Everybody wins. And that does occur in some instances. The argument ultimately is, however, that that's a form of corporate social responsibility that is better left to business, because private international law predominantly defers to contractual interests. If you choose the particular law that applies, if you choose the particular forum, most states will defer to that choice. And so this win-win formulation is promoted by various actors, including UNCTAD, the United Nations Conference on Trade and Development. In biodiversity, they refer to something called biotrade, which is essentially achieving biodiversity through trade. Now, this raises all kinds of issues. It dates back to those enforcement issues. It relates to issues of greenwashing, sort of putting forward green credentials to support your business or market case, but without necessarily making those contributions to sustainability. And it only seems to work well so far in relatively price inelastic fields. So in those small stakeholder land plots, for example, in relation to vanilla, certain botanicals and cosmetics and fragrances, where you can change the price of the end product without having a huge impact on demand for the product. That seems to have worked quite well, but seems to struggle in bulk and commodity products. For example, palm oil. I'm sure a lot of you are familiar with the EU's approach and discussions about Malaysian and Indonesian palm oil there. So the role of private international law there is broadly a facilitative one, although it has to be recalled that private international law is a series of domestic laws predominantly. What ideally would work here is a global form of certification regime, where the quality of a particular certification measure, i.e. this product improves or at least does not harm biodiversity, could be improved. And the second conception, so that's law as win-win, and then there's law as regulation, where private international law also has a role to play. And this is primarily via actions brought in tort law. There's been a series of cases, including in Australia, in the UK and the Netherlands, applying Nigerian English law, essentially. You might be familiar in Australia with the case of Sharma, which Justice Bromberg, it's being appealed at the moment, found a novel duty of care based on personal injury arising to children for future climate change contributions. Now, I think that judgment is open to attack and it is being reviewed, but there have been other decisions extending jurisdictional claims. Hans mentioned a couple of these in Okabe and Shell, stemming from Vedanta, which had to do with parent companies' liability for actions of their subsidiaries. So commonly, for example, in Nigeria or in Zambia, I think in other places, there were oil spills or some environmental harm. And the question that was raised was, can a entity headquartered somewhere else, usually in a developing country, have responsibility for these concerns? And the answer was yes, which was taken to its conclusion in the Milieu Defensie and Shell case, which was a Hague Court of Appeal case, but Hans will correct me if I'm wrong there, which was whether simply by having a group policy in relation to how your subsidiaries operated, could you be said to have a duty of care towards those that were harmed through your contribution to environmental harm in a third country through the actions of your subsidiary. So there's been some novel case law extending the boundaries of how private international law applies, and predominantly the EU has led these initiatives outside of these common law cases I referred to. Now, I'm conscious of time, so I'm skipping through this quite quickly and not going into a lot of detail on private international law, but I do welcome any questions as they come up. One thing I would like to focus on is those are sort of some of the smaller changes that have occurred at the margin. So we're slightly extending the jurisdictional reach of a court that allows for environmental protection. We're potentially excluding procedural rules like the forum non-convenience rules, which often corral you into a court, into a jurisdiction which has relatively lax environmental concerns. So bit by bit, those jurisdictional rules are being eased to make it easier for plaintiffs to promote sustainability interests. Simultaneously, however, and I think this book and this project broadly conceived can contribute quite a lot to this, there are moves to change the overall landscape. Now I'm just saying, no, you haven't given me my 3-minute warning yet, Stacey, have you? Okay, I must have a few minutes left. 3 minutes, there we go. Broadly conceived, and this will be a very, very high level summary, is that they can sort of fit into two categories that we're familiar with, particularly in common law style jurisdictions. We have the due diligence and reporting requirements, and they're seen often in forms of legislation like modern slavery legislation, or the EU's proposal, or the UN's proposal as well, for certain due diligence and accountability requirements, which are getting increasingly sophisticated and increasingly crystallizing liability for private actors in a concrete way. And that brings us to roundabout to the earlier Hague Convention, which I mentioned did not succeed in 1993, which was an entire multilateral convention on this question of environmental liability, and reinforces my point that this is broadly a political distinction that can be facilitated by legal rules, but requires political will. Now, this convention touched upon all aspects of private international rules, including jurisdiction, applicable law, and recognition and enforcement, and liberalised them to the extent that it made pursuing and seeking and achieving justice for environmental damage claims easier than otherwise under general private international law rules. And so, for example, you could have a choice as to where to bring an action under a range of different places where the damage occurred, where the harm was felt, and so on. And it narrowed the traditional grounds for refusing recognition and enforcement. So my ultimate thesis in relation to sort of the conclusion of SDG 15 is that when we look at this almost 30 or 40 years beyond when this convention was first floated, the rationale for action has only gotten more urgent, and state commitments have only increased. Those state commitments increasingly reference private action. And I think at this point, what we're looking for is not just tweaks, but moving to a broader conception of civil liability and the contribution of private law and private international law to achieving sustainable development. I'll stop there. Thanks very much.
Thanks very much, Drosos, for kind of bringing us home in a very poignant and pointed manner. I think there's a lot of us who would love to take a look at that draft convention. If you can remember the name or put the name down, maybe in the chat, some folks may want to take a look at that. We have a few questions on the Q&A. Other people may be so busy listening that they haven't formulated their questions yet. We'll take the questions from the Q&A session. I know some of our speakers would like to comment and kind of interact just a little bit. So after we do the questions, the 3 questions we have pending, we'll let the commentators talk to each other a bit. And maybe during that time, we'll have some more questions arise on the chat here. So the first question really, I believe, goes to Hans. Basically, it says, Hans, you were talking about enabling public responsibility and the ability to exercise rights. Often we are aware that people are unable to exercise their rights or unaware of their rights. Have you seen any impact from the country's governance on this particular topic?
That's an interesting question. I think the book brings out the problem that the SDGs tend to to aspire for more activities on the part of states, and we see, for instance, in the chapter on life in the sea, that it is mentioned that there is this UN Convention on the Law of the Sea, UN Convention on Biodiversity, which establish obligations of states, but do not give, for instance, seashore communities rights to go to court and act and get their rights recognized. So I think the message of the book is that much more should be done, in fact, indeed, to enable stakeholders to assume that, and the idea of a global environmental treaty, or the idea of a global treaty on migration that emphasizes the rights of individual and the movements of individual migrants, those ideas should get much more attention. Vivienne mentioned the possibility that contracts exclude the true stakeholders, and that private international law is complicit in that, and should change its attitude to make sure that all the relevant interests should be taken into account. So we have a whole agenda for us to recognize the role of citizens in shaping shaping our world. So I agree that it is work for us to do.
Okay, great. We have two more questions left, and I'm actually going to take them out of order because I think the one that came in second is a good question for everyone to take. There's a question from Anisa Casanova, which is really, I think, focused towards Vivian because it talks about her case study on the Bahamas resort. So following on from that example, we can say that the dispute resolution by the investing state tends to incline towards unofficial dispute resolution mechanisms, diplomatic, close negotiations, et cetera, particularly in cases involving China. In those situations, what can a host state do in order to pursue sustainability, given that it is a developing country, perhaps weak in certain ways, and the rule of law may not be strong? Or should that be controlled in some way?
Yeah, well, that's a question that could get a book in itself, I think. I think the difficulty with the Bahamas case really did go back to the way in which the whole thing was structured. Because essentially the state of the Bahamas wasn't actually a party to any of the agreements as far as I could see, although it had given all sorts of assurances and concessions to the developers. But the underlying problem in the transaction appeared to be the progress of construction, which was, as I said, done by a subsidiary of a Chinese construction company, which presumably is how the China Exim Bank came into the deal, or vice versa. You don't know how it happened that way. But in order to take action against the construction company, all of that litigation had to be conducted in New York and to go through a whole very lengthy process in New York. So while all of that was happening, then the whole thing essentially came to a close. So the deal that was reached by government intervention, which was reached in China, essentially excluded the developer, which is why the developer is still litigating. As that is, as far as I can understand, the very sort of complex progress. But it does seem to me that if the transaction had been set up in such a way that the government did actually have more participation and more rights to participate, and more of it was based in the Bahamas in terms of dispute resolution, that this would have been very helpful for the government's position. And I don't think you can say about the Bahamas that it's necessarily a place with a weak rule of law. You know, it may be a small country, but it has a pretty solid legal system, and it's got access to, even if they're not there, a lot of very good lawyers and a very sound judiciary. So I do think that the way in which it was structured did contribute significantly to the various problems. I mean, I think that a lot of the issue is that people will say, oh, well, we're not going to do it in your country without actually even looking at the legal system. They just say, this is project finance, right? We do it under English law. Or I was reading an article saying that when it comes to lenders, they just say, oh, well, we're French, we do it under French law. And that's it, no negotiation.
And certainly Vivian has the experience from the negotiation and the transactional side, and I have it more from the dispute resolution side when I was practicing in London and New York, and constantly had parties claiming that they wanted the dispute governed by their home law, despite the fact their home law actually was going to be worse for them. And that's not even taking sustainability issues into account. Vivian laughs, but you know, yeah, I had a lot of American clients and they are nothing if not parochial. So let's go to
Georgia. Let's have the law of Georgia.
Yeah, yeah, the well-known international law of Georgia.
Yeah.
Tibor Moldnar has given us a question that I think is really suitable for everyone and strikes a bit of a note of kind of practicality. I don't want to go all the way to say cynicism, and says the SDGs are noble aspirations, but where's the enthusiasm for the realization? Tibor mentions that there was a conference here at the University of Sydney a few years ago where Australia was shown to be on track to possibly achieving just one of them. If the COP26 is any guide, there appears to be global disinterest in SDGs because countries have other priorities. So now that the SDGs are agreed, what is it going to take to make it happen? And then in parentheses, before humankind destroys itself. On that note, anyone want to jump in on that first? All right, go for it, Veronica.
I'm happy to go for it. I appreciate the question and the perspective. And I think one comment is that I think taking the polycentric nature of the SDGs and what comes clearly from the project is that we need to move beyond thinking about countries and states particularly as the only actors that we're paying attention to, and focusing on the private sector and focusing on civil society and kind of engaging ourselves in what can each of us do in relation to the agenda. So I think it is very ambitious. It will take all of us. It will take all of the sectors to engage in that way with this agenda concretely, but with the issues that we have to tackle. I think the end of that question is otherwise we'll destroy ourselves, and this is what is so urgent that we actually take this on board. And so that will be my response to that. But I'll take the opportunity to just make a brief comment in terms of something I think comes very clearly from both Vivian's and Rosso's chapters, but also throughout the book. And I think it's important to keep that in mind through the discussion. And it's this kind of both functions of private international law, the regulatory function and the enabling or facilitative function. And when we think about private international law, the enabling function, the facilitative function, when we think about choice of law and choice of court, comes up times much more prominently than the regulatory function, or we tend to limit the regulatory function to sectors. For instance, if we think about consumer protection, we think about the regulatory function of private international law. I think what comes clear from the book and from these fantastic chapters, and we also pick that up in the introduction, is that private international law has a regulatory function beyond consumers, beyond employees, and in that exercise of the enabling function, it is very important that the assessment is not in that way deprived from any substantive outcome. So that way of thinking about private international law as a purely technical, procedural mechanism, I think it doesn't go with thinking about the contribution of private international law to sustainable development. So I think in that way, the reconceptualization of private international law engaged with sustainable development comes as a very strong message from the book, and invites us to rethink and reconceptualize and live in a way aside that purely formalistic, technical, deprived from substantive outcomes kind of traditional conception of the discipline. But yeah, I leave it there. Thank you.
Thank you, Veronica. Others either responding to Tibor's point or to the point that Veronica just made? Rosas, I love that your cat has made an appearance. I have a small dog locked away.
Oh, right, yeah. Yes, Luca loves. I might as well say something now that I'm on the spot. A few points sort of for the question before and this one. It's sometimes the developing state also that doesn't want to pursue the sustainability actions that come through a private actor as well, because doing so can show that you're hostile to foreign investment. And there's a regulatory arbitrage kind of point where if I can go down the road to another jurisdiction, why would I go somewhere where I don't have complete or essentially free rein to operate? And that's a very cynical view. And I'm not trying to suggest that sort of corporations are by and large seeking to destroy and cause environmental damage and so on. It's just that they're given quite a degree of latitude in pursuing their own investment activities. And there's no real consideration of the broader public interest or the byproducts that arise, the negative externalities from their actions. And I guess that's why the call of this book is so interesting, because it's saying we need to take stronger steps to engage with the actors who actually partake in these activities. It's not states, for the most part, that are engaging in these harms. At worst, you can say they are not disciplining or regulating as effectively as they could. So we're almost jumping to an intermediary where the real harm is arising through the activities of transnational corporations and their various either outsourced or subsidiary style relationships. I don't have an answer other than to shut down global production around the world that really achieves sustainability goals, but that's what we're trying to shift towards, more of a sustainability rather than a developmental metric. And I know in public international law in particular, there's been a real capture of the developmental interests above and beyond the sustainability interests. And I think the same is true in private international law. Its facilitative capacity, as Veronica said, has really been the primary emphasis. And I think that's an intentional decision of sort of capitalist corporatist structures. And it's about reframing that, I think, and thinking about how states can limit, control, police in a unified way, keeping in mind the regulatory arbitrage concerns.
Other thoughts from the panelists, or I'll take us in another direction if we're ready. So one of the things thinking about, again, what private international law can do, this thought came to me listening to Vivian and to some extent also to Drossos, this concept that we have these private actors, corporations for the most part, and it is difficult to regulate because there may not be the political will there, and certainly not universally, and they may go to jurisdictions that have a less rigorous regulatory regime on environmental concerns. And I certainly saw that back when I was in practice back in the 90s. What do you think of the concept of nudges? Thinking of Cass Sunstein, Richard Thayer's book on nudges as a way of allowing autonomy to exist, but making certain choices more difficult by creating perhaps default rules that are pro-sustainability and requiring parties to transact out of them and to incur those transactional costs, and perhaps the reputational costs for stepping away from what might be perceived as the optimal approach. Do you think that these kinds of nudges in standardized contracts, perhaps in the infrastructure realm, would be useful, Vivian, or do you think that they are so individually transacted at this point that there is no room for a default regime that would shift the kind of the standard towards more sustainable practices?
I think it's a great idea. I don't know whether you could do it given how much is already tied up institutionally in these existing structures. I mean, not just do you have the law firms and then you have the banks and then you have everybody's standard forms, even with the international banks, I found a clause sort of saying, and the law won't be the law of the host state, except when it has to be as when you've got security over land. And then you have all of this talk about risk mitigation, and then when the World Bank Partnership Group was criticised for that, they changed all of the risk mitigation expressions to bankability, right? So it's not our fault, guys. We had nothing to do with this. It's just all up to the banks because it has to be bankable. And it just seems to me that you might need more than a nudge to get people actually to think about, as you say, what is the best jurisdiction? And if this is not a suitable jurisdiction, how can we make it a suitable jurisdiction? Or how can we give the host state and its interests a bit more of a role in the whole thing? And I don't know how you do that without changing the current setup, but maybe there's some way.
And maybe now's the time when people will start thinking about that. What with more ethical investments. So here's a general rule. Do you guys think generally that the ethical investment movement is going to start to move any of these private actors? Drossos has been very clear that he feels that multinationals bear a large role in the current problem. Do you think that the little people, the investors, can start to shift that in any way? Drossos or anyone?
Yeah, I might jump in on that behaviour point as well. There's also nudges to consumer behaviour, of course, which is the predominant way that we offload responsibility most of the time. Pollution is a problem, rubbish is a problem. It's not McDonald's, it's the little consumer that throws the disposable packaging away. So things like eco-labels and credentials, there's a role for private international law to play there in giving effective teeth to global standards and actually raising the bar about the minimum sort of legal standards in play.
Because it seems to me that part of the problem is political will, whether you're talking about a government or an individual. I mean, our will to, when I moved to Australia, I was very pleased because now I could literally start hanging my laundry out to dry as opposed to using my drying machine, which I've done for the rest of my life. And I'm like, oh, good, my norms are now in line with the rest of the world, and there's an actual line outside. But do we think that part of the problem is this political will, individual, corporate, or national, or is it lack of knowledge I mean, to some extent, yes, we all know we're supposed to recycle our newspapers and our plastics, et cetera. So I agree, sometimes knowledge is not there. But overall, do we think we need more policy makers coming up with ideas on how to help the banks, or how to help the different actors, with the insurers, for goodness sake? That's a big moneymaker. Do they just need good ideas from scholars like us?
And they need to kick up the butt too with the with changes to civil liability rules. When you change the rules in relation to duty of care, and you take more care in ensuring your subsidiaries don't engage in conduct that leads to an oil spill, you might look more closely when your bottom line and you have to report it and your bonus is in play. So that's the hard knocking effect. But absolutely, the idea that we can contribute through scholarship in framing the debate, I think, is one of the huge benefits of this book. But I think the editors would probably have a lot more to say than I would on that.
And Veronica is ready to go. Go for it, Veronica.
Yes, no, I completely agree that education is a huge part of this. And of course, education for the goals is part of the UN program altogether. And there are the educational programs that goes to that. But I think also there's a lot of and I think this is truly important in the agenda and beyond, of education in intercultural competencies, and education in understanding the completely different scenarios and where the SDGs needs to play a role. And I think that if it's something that private international law brings to the fore as well, is that working with diversity. So differently from public international law frameworks, where kind of the universalism is the rule, then private international law deals with that diversity. So in that sense, there's also an element that comes from that, you can say it educational as well, but it's a contribution of private international law as a discipline in this conversation, that I think it is important and helps promote that individual, corporate and private sector engagement. And relating to that, SDG 12, that is about responsible consumption, and it was actually written by Geneviève Sommier, and engaging very much with that consumption responsibility, and that idea of including labeling and other ideas. I think bringing ideas to the conversation is really important, and kind of thinking of possible plans of action to engage further. But as I said, in a very inclusive way, engaging with all relevant stakeholders. But yeah, thank you.
Absolutely. We have hit time, so unless any of our speakers are just chomping in the bit to have a last word, I think that concept of, all of us taking responsibility and all of us thinking outside the box of new ways to deal with things. I can't avoid my Americanisms occasionally, but it's in the evening here, so I'm sitting in the semi-dark. Maybe I won't turn on the lights, and I'll just kind of sit here quietly in the dark, play with my dog. That's a very low environmental impact for the evening. But please, everybody on the call, please join me in thanking our fantastic speakers and congratulating them on a wonderful project. I hope that you all go to the link, look at it. Again, very environmentally friendly. You can just look at the digital copy. Congratulations. Well done. Have a great evening or day wherever you may be.
Thank you so much.
Thank you.
Thank you all.
Bye, guys.